Okay, let's unpack this. Today we are undertaking a deep dive into the case of Ryan Ferguson, which stands as a profound and frankly chilling monument to institutional failure. It's a story of a high school junior wrongfully convicted and incarcerated for, well, nearly a decade.
It really is more than just a failure, though. It's almost like a detailed blueprint showing exactly how the justice system can prioritize closing a cold file over the pursuit of objective truth. It really exposes the fragility, of the foundations upon which so many convictions are built, memory and testimony.
That's definitely our mission today, to unpack the source material and track the mechanics of this injustice. We're focusing on Ryan W. Ferguson, who at just 17 was charged and then convicted back in 2005 for the 2001 murder of Kent Heitholt in Columbia, Missouri. The core, sort of unbelievable fact here is that this conviction happened despite a complete lack of physical evidence.
Right.
It relied solely on the testimony of two key witnesses who, well, later recanted their statements, both claiming intense coercion by the state.
Exactly. And this deep dive becomes a critical masterclass, really, in wrongful conviction studies. We're going to trace the path from unreliable memory through prosecutorial misconduct, specifically some really severe Brady violations.
We'll definitely get into those.
Oh, yeah. And then the intense multi-year legal battle for exoneration led by his family. We'll also look at the staggering financial accountability demanded years later. I mean, this involved legal reversals, serious allegations against the former prosecutor who, remarkably, had actually become a circuit court judge by then.
Wow.
Yeah. The stakes here are just immense, covering personal liberty, institutional integrity, and, multi-million-dollar civil settlements.
So let's start right at the beginning. The night of November 1st, 2001. Setting the scene for a crime that would, kind of shockingly, remain unsolved for 2 whole years. The victim was Kent Heitholt, the sports editor at the Columbia Daily Tribune, killed in the early hours of the morning right there in the paper's parking lot.
And the initial timeline is pretty precise, and it's crucial. Heitholt was last seen alive by a coworker, Michael Boyd. Boyd spoke with him in the parking lot sometime between, say, 2:12 a.m. and 2:20 a.m.
Okay.
He was beaten severely with some kind of blunt object. The specific type, interestingly, was never conclusively identified by the police, and then he was strangled.
Strangled with what?
With what was later determined to be his own belt.
Grim detail. Okay, so just minutes after Boyd left.
Yeah, just minutes later. This is when the first key witnesses arrive on the scene. A janitor working at the Tribune, Shauna Ornt, she went outside for a smoke break, apparently.
Right.
And she saw 2 shadowy figures near Heitholt's vehicle. Got alarmed, obviously, immediately went back inside to get her supervisor, Jerry Trump.
Okay, makes sense.
So when Ornt and Trump came back out together, they observed 2 college-age men standing near the car. They reported hearing one of the men yell something like, "Someone's hurt out here, man," before they just hastily walked away, kind of disappeared through a nearby alley.
And then they called for help.
Right. They alerted others, and the 911 call was placed at 2:26 a.m. So, we're talking about a window of maybe 10 to 15 minutes between Heitholt being seen alive and the janitors discovering the scene and seeing the perpetrators leaving. It's a very tight time frame.
Okay, so the initial investigation,
Yeah.
they found physical evidence, right? But it didn't immediately point anywhere.
That's exactly it. The police collected unidentified fingerprints, both from the outside and the inside of Heitholt's car. And critically, an unidentified hair was found clutched tightly in Heitholt's hand, which really suggests a struggle with the attacker.
Definitely.
Footprints were also recovered from blood at the scene.
So prints, hair, footprints, sounds like solid evidence.
You'd think so, but here's where we see maybe the first systematic breakdown. All this physical evidence, the prints, the hair, the blood footprints, it matched absolutely no one the police initially suspected or interviewed. Yet, the investigation almost immediately fixated on the human witnesses, especially the janitors. Shauna Ornt claims she got a good look at the young men, and based solely on her description, a composite sketch was created.
But wait a minute, you said there were 2 witnesses, Ornt and Trump. Did their accounts match up right away?
Well, that's the red flag that seems to have been largely ignored at the time. Jerry Trump, the supervisor, actually contradicted Ornt's confidence. He stated pretty clearly that he was unable to see the men clearly.
Okay, so one says clear view, the other says not so clear.
Precisely. So right from the outset, the police had this conflicting foundation. One witness claiming strong identification ability, the other admitting, difficulty seeing. And when an investigation chooses to elevate the testimony of the one who claims certainty and sort of sideline the uncertainty of the other, well, that signals a potential for confirmation bias, doesn't it?
Yeah, It really does. They leaned heavily on Orn's description, even though Trump's caution probably should have made them pause.
Exactly. It should have tempered that reliance.
So, while all this is happening, or rather not happening with the investigation,
Right.
what about the two young men who would eventually be charged? Ryan Ferguson, 17, high school junior, and Charles Erickson, his classmate.
Right. The sources detail their movements that night pretty carefully. They were out partying. It was Halloween night, apparently consuming significant amounts of cocaine and alcohol.
Okay.
They met Ferguson's sister at an underage bar called By George, ran out of money, apparently, and left the bar relatively early, somewhere between 1:15 a.m. and 1:30 a.m. This timeline becomes absolutely paramount later on,
Why is that?
because it would be disputed during the trial, and ultimately, proving this early departure time provided one of the final crucial pieces of evidence proving Ferguson's innocence.
Got it. And crucially, Charles Erickson, he was extremely intoxicated.
Extremely, to the point where he suffered what we now understand as intoxication-induced amnesia, basically a blackout. The technical term is anterograde amnesia for the entire period after leaving the bar.
So he just couldn't remember.
Exactly. The source material explicitly notes he had no memory of what had happened. And importantly, he didn't notice anything unusual the next day. No injuries on himself, no blood on his clothes, nothing like that.
And for 2 years after that night, the case just went completely cold.
Yeah, that's the typical trajectory, unfortunately, for a high-pressure cold case. Investigators are under immense pressure, right? And when the objective evidence, the forensics, the science, fails to deliver a suspect, they often turn, perhaps inevitably, to the human element.
Looking for a tip, a witness.
Exactly. The failure to match the fingerprints or the DNA from the hair to anyone in any known database should have been this constant reminder that they were likely missing the actual perpetrator. But instead, it seems they just waited for a human tip, which unfortunately set the stage for manipulation through suggestion. The environment was just, well, it was ripe for a coerced narrative to take hold.
And that human element finally arrived 2 years later, October 2003. And it was driven entirely by Charles Erickson's own intense anxiety. He saw some local media coverage revisiting the murder, which, remember, happened just blocks from where he and Ferguson had been partying that night.
Right. And this anxiety quickly morphed into something much more complicated. It seems like the formation of what you might call pseudo-memories. Erickson started having these highly distressing, very fragmented dreams about the crime.
Dreams. Like he thought he remembered something.
Not clearly. It's actually a common psychological response, when a vulnerable individual realizes they were physically near a traumatic event that they genuinely cannot recall due to something like a blackout. He became consumed by the possibility. He actually started asking Ferguson, hey, do you think we could have been involved?
And what does Ferguson say?
Ferguson strongly reassured him, said absolutely not, that he was certain they had just gone home after the bar.
But Erickson couldn't let it go.
No. The concern just spiraled further, especially when Erickson saw a newspaper article in November 2003. It included the composite sketch of a possible suspect, remember? The one based on Shauna Orn's description from 2 years earlier.
Yeah.
Erickson felt it resembled him.
Oh, wow.
Yeah. And that's when he sought advice from a friend, Nick Gilpin. Gilpin then told another friend, John Alder.
And Alder?
And John Alder, based on this secondhand worry, this maybe I look like the sketch anxiety from Erickson, called the police. And he implicated both Erickson and Ryan Ferguson.
Just based on that. A dream and a sketch resemblance.
Apparently so. This single phone call immediately steered the entire investigation toward these two specific targets, effectively disregarding the 2 years of failed forensic attempts and the lack of any physical link.
This brings us to the interrogation of Erickson, recorded interrogation, which is just. It's the absolute pivot point of this entire wrongful conviction story. The sources detail how riddled the interview was with flaws and massive red flags.
Huge red flags. Erickson repeatedly told the detectives interviewing him that he had a foggy memory. He actually said, and this is a direct quote from the recordings, "I could be sitting here fabricating all of it." He admitted point blank he knew nothing concrete about the actual crime.
So the police knew he couldn't remember.
They were dealing with a subject who was clearly anxious, probably feeling guilty about his drug and alcohol use that night, and crucially, afflicted by genuine amnesia, a blackout. But instead of carefully testing his memory, seeing if he held any independent details, it really looks like they coached it.
Oh, so?
Well, when they started pressing him for details about the weapon used to strangle Heitholt, Erickson initially guessed completely wrong. He first guessed maybe it was a shirt, then maybe a bungee cord.
Wild guesses.
Totally off base. Then the detective intervened and explicitly told Erickson the murder weapon was the victim's own belt. Fed him the answer.
And what was Erickson's reaction when they told him that crucial, non-public detail?
His immediate, spontaneous reaction caught on tape was, "I don't remember that at all."
Wow. That says everything.
It really does. That is the defining moment of that interrogation. Police are supposed to verify knowledge, right? Not provide the script.
It's like the mechanism of a false confession just laid bare.
Absolutely. Erickson had to avoid that anterograde amnesia. The police, likely wanting desperately to close this high-profile cold case, essentially provided the missing puzzle piece. The belt. And the psychological literature on this is pretty clear. Once police supply a critical fact like that, a vulnerable subject, especially one in Erickson's state, can internalize it. They might start to feel a sense of false recall or simply believe the information must be true because the police, these authority figures, confirmed it.
So after what the sources describe as much prodding.
Yeah, after much prodding, Erickson eventually fabricated a story implicating himself and Ryan Ferguson, claiming they'd robbed Heifelt for drinking money.
So after 2 years of silence, the case finally breaks open. Not through DNA, not through fingerprints, but through the coerced, anxiety-driven, and highly unreliable testimony of a young man who literally admitted he couldn't remember anything and was apparently fed the key facts by the interrogator.
That's the crux of it. And in March 2004, based almost entirely on this interrogation, Erickson and Ferguson were arrested and charged with murder and robbery.
And the investigation, which had been completely cold, suddenly had unstoppable momentum.
Exactly. And the government immediately offered Erickson a massive incentive, a plea deal. Reduced sentence in exchange for his testimony against Ferguson.
So the most unreliable narrator imaginable
Becomes the state's star witness. It transforms Erickson from someone admitting fabrication into the key piece of evidence against Ferguson, basically sealing Ferguson's fate before the trial even properly began. This is the moment a fundamentally flawed foundation turns into the official case narrative.
Okay, so we get to the trial in 2005. And it really hinged entirely on the state's ability to sell this coerced narrative to the jury, didn't it? They somehow had to make two fundamentally unreliable witnesses, Erickson and the janitor, Jerry Trump, appear credible enough to outweigh the complete lack of forensic evidence.
It required a really dramatic shift, particularly in Erickson's persona. Remember, this is the same individual who repeatedly told police he had a foggy memory, that he might be fabricating details, the one who had to be told about the belt.
Right.
Suddenly, he appears on the witness stand and provides this meticulously detailed description of Ryan Ferguson strangling Kent Heitholt. He testified to a version of events that was, essentially a police-induced memory, built piece by piece during that flawed interrogation.
And then there was Jerry Trump, the janitor supervisor. His testimony was meant to provide the visual corroboration, right? Yeah.
Exactly. Trump testified that years after the murder, while he was serving time in jail on some unrelated charges, his wife supposedly sent him a newspaper article. He claimed that upon seeing photos of Erickson and Ferguson in this newspaper, he instantly and immediately recognized them as the two men he saw standing over Heifelt's body 4 years earlier.
That sounds like a very convenient, dramatic moment for the prosecution.
Extremely effective. It provided the illusion of this objective, non-biased eyewitness identification, despite, remember, Trump's earlier admission that he couldn't actually see the man clearly on the night of the crime itself.
So his memory suddenly got crystal clear 4 years later in jail.
According to his trial testimony, yes. It's the definition of convenience, really, for a state trying desperately to overcome a complete void of scientific evidence linking their suspects to the crime.
And the defense. What could they do against these compelling, though flawed, testimonies?
Well, the defense had to counter this emotionally resonant testimony with cold, hard science. They hammered home the fact that none of the critical physical evidence, the unidentified hair clutched in the victim's hand, the fingerprints on the inside and outside of the car, the blood footprints at the scene, none of it matched either Ryan Ferguson or Charles Erickson.
That seems pretty definitive.
You would think so. Furthermore, they stressed that there was absolutely no trace of the victim's blood or any other physical remnant of the attack found in the vehicle Ferguson was driving that night, which, you'd absolutely expect if the perpetrators had been involved in such a violent, bloody struggle and then got into that car.
So strong exculpatory evidence pointing away from guilt.
Absolutely. Yet somehow it was dismissed or outweighed in the jury's mind.
Which brings us to that really profound and disturbing question about jury decision-making, doesn't it? Why? Why did the jury trust the highly changeable, uncorroborated testimony of a confessed co-defendant who initially claimed amnesia and a janitor whose convenient identification popped up years late while he was in jail? Why trust that over the objective, absolute silence, the forensic evidence?
It really speaks to the power of narrative, I think, and perhaps confirmation bias within the courtroom. Forensic science, let's face it, can be abstract. It can be confusing for a jury. It often requires technical explanation, and sometimes it just leads to an inconclusive result, which isn't satisfying.
Right, people want answers.
Exactly. In contrast, a compelling story, I saw him do it, or a dramatic moment, I instantly recognized him in the newspaper, provides a sense of certainty. It offers closure. And when a jury feels, maybe subconsciously, immense pressure to solve a violent crime in their community, they often gravitate towards the testimony that seems to simplify the truth, even if that testimony is, well, manufactured.
So ultimately, the jury sided with the narrative, not the science.
It appears so. Ferguson was convicted of second-degree murder and robbery, and he was sentenced to 40 years in state prison. It was a victory for the prosecution, but one built on shifting sand, really, ready to collapse the moment the coercion and the lies behind the key testimony were finally exposed.
And the systemic failure here seems to be rooted in that investigatory path, right?
I think so. It seems once the police decided Erickson and Ferguson were their guys, the pressure shifted. It wasn't about finding the killer anymore. It became about confirming these suspects' guilt. Every subsequent action coaching Erickson, finding a way to get Trump to identify them years later, seems driven by this kind of backward-looking confirmation bias, which fundamentally undermines the integrity of the whole judicial process.
Spending nearly 10 years in prison for a crime you didn't commit. It's just a living nightmare to contemplate. But the hope for justice was kept alive largely by Ryan's father, Bill Ferguson. His relentless advocacy became pretty famous in its own right.
Absolutely. Bill Ferguson's fight was extraordinary. Then, in 2009, a major development. The renowned Chicago attorney Kathleen Zellner took over Ryan's case pro bono. That signaled the fight was escalating, becoming much more sophisticated legally.
Zellner has a reputation for this kind of work, doesn't she?
Oh, absolutely. She's known for her incredibly meticulous, almost forensic approach to legal defense, specifically targeting systemic flaws in convictions, like suppressed evidence and police misconduct. She didn't just challenge the conviction itself, she went after the mechanics of how the coercion occurred. And that investigation led directly to the critical recantations in 2012.
Okay, so this is when the state's narrative truly starts to fall apart.
Completely. Both key prosecution witnesses, Charles Erickson and Jerry Trump, recanted their trial testimony. They provided sworn statements to Zellner and her investigator, admitting flat out they had lied on the stand.
Let's break down those recantations. They're crucial. What did Erickson say?
Erickson testified in a habeas corpus hearing now. For the listener, habeas corpus is a legal challenge to the legality of the detention itself, basically forcing the court to review new facts or constitutional issues not fully addressed at trial.
Okay.
Erickson testified under oath that the former prosecutor, Kevin Crane, had pressured him relentlessly into implicating Ferguson. He maintained consistently now that his blackout the night of the murder was real, and his detailed trial testimony was entirely fabricated under duress, primarily to secure his own plea deal and avoid a much harsher sentence.
So he's saying Crane coerced him. And what about Jerry Trump? His admission sounds equally damning.
Maybe even more so, because it directly implicated the prosecutor's office in actively manufacturing evidence. Trump completely recanted his dramatic story about his wife sending him the newspaper in jail. That never happened, he admitted.
So how did he see the photos?
He admitted that he first saw photos of Ferguson and Erickson after his release from prison, specifically at the prosecutor's office in 2004.
In Crane's office?
Yes. He specifically claimed that Crane showed him a Tribune newspaper featuring Ferguson's photo and repeatedly stressed that identifying Ferguson would be helpful. Trump described Crane's demeanor during this as acting almost like a cheerleader, just encouraging the positive identification until Trump finally agreed.
So it wasn't an independent identification at all?
Not even close. It was a guided performance explicitly designed to secure the conviction by manufacturing corroboration that didn't exist.
But Zellner's team didn't just rely on these recantations, right?
Yeah.
They went digging for evidence the state might have hidden.
Exactly. This is where the really severe Brady violations were uncovered. And just to clarify for everyone listening, a Brady violation occurs when the prosecution withholds evidence that is favorable to the defense evidence that could potentially lead to an acquittal or maybe mitigate the defendant's sentence. It's a major constitutional violation.
And in this case, the violations were significant.
They were numerous and absolutely damning.
What were the most critical pieces they found that had been withheld?
Okay, first, directly related to Jerry Trump's fabricated story. Zellner's team questioned the original investigators. Under pressure, they were forced to admit they had interviewed Trump's wife back then, and she had explicitly told them that she did not remember ever sending him any newspapers while he was incarcerated.
Wow. So the prosecution knew Trump's story was likely false.
They had direct evidence contradicting it. This single piece of information, which would have completely destroyed Trump's credibility on the stand, was deliberately withheld from Ferguson's original defense team. The Missouri Court of Appeals later characterized this specific withholding and others as a pattern of nondisclosures.
Unbelievable. And it wasn't just about Trump, the secondary witness.
No, the suppression extended even to the original eyewitness, Shauna Ornt. Remember her? The janitor who claimed she had a good look at the perpetrators that night, the one whose description led to the initial sketch.
Yeah. But she never testified at Ferguson's trial to identify him, did she?
No, and there's a reason why. Ornt testified later during the appeal process that she had actually told Prosecutor Crane before the trial that the man she saw on the night of the murder was definitively not Ryan Ferguson.
She cleared him to the prosecutor.
Yes. And she claimed that when she refused to implicate Ferguson, Crane became verbally threatening during their final conversation before trial.
So the prosecution buried her testimony because it was exculpatory.
That's the inescapable conclusion Zellner successfully demonstrated. The prosecution knew Ornt's testimony would shatter their case against Ferguson, so they intentionally suppressed her as a witness and kept this vital information hidden from the defense. Another major Brady violation.
So witness coercion, witness suppression. What else did the defense uncover?
Beyond the witness issues, they found objective evidence that completely destroyed the entire time frame the prosecution had relied on during the trial to place Ferguson at the scene.
Ah, the timeline discrepancy we talked about earlier.
Exactly. This provided the sort of factual smoking gun. At trial, Erickson, in his coach testimony, had claimed that he and Ferguson returned to the bar by George around 2:45 a.m. after the murder, which we know happened around 2:20 a.m. He claimed they stayed until maybe Fort Nero or 4:30 a.m. and even spoke to the bouncer, Mike Shook.
But that wasn't possible.
Completely impossible. Zellner's investigators tracked down Shook and other patrons. They obtained solid evidence confirming that the bar by George had actually closed at 1:30 a.m. that morning.
1:30 a.m.
Yes. Erickson and Ferguson had left between 1:15 and 1:30 a.m., making it physically impossible for them to have returned to the bar after the 2:20 a.m. murder occurred blocks away. This one objective, verifiable fact proved Erickson's trial narrative about their movements was utterly fabricated.
So you have recantations, documented Brady violations, and now proof the timeline was impossible.
Right. The culmination of all these factors, the recantations admitting lies, the proof the prosecution hid exculpatory evidence, and the objective timeline impossibility led the Missouri Court of Appeals Western District to finally vacate Ryan Ferguson's conviction in November 2013. Their decision was scathing, citing specifically a pattern of nondisclosures by both police and prosecutors.
And after the conviction was vacated, did the state try to re-prosecute?
No. The appellate court's ruling was so strong, pointing out very clearly that there was, and I quote, no evidence left that would support a conviction. Recognizing the futility and, frankly, the injustice of a retrial, the Missouri Attorney General's office declined to refile charges. They publicly acknowledged that Ferguson had presented overwhelming evidence of his actual innocence.
And so, Ryan Ferguson was finally released.
Yes, on November 12, 2013, after spending nearly 10 years in prison for a crime that the courts ultimately determined was pinned on him through serious institutional malfeasance. And crucially, we have to remember, the murder of Kent Heithel remains officially unsolved to this day.
Okay, so Ferguson is finally free, exonerated. But the legal fight wasn't over, was it? It immediately shifted from criminal defense to seeking civil accountability.
That's right. On March 11, 2014, just months after his release, he filed a massive civil rights lawsuit. He was seeking damages, and he named 11 individuals, including the former prosecutor, Kevin Crane, who by then was a judge, and several police officers involved in the original investigation, as well as Boone County and the city of Columbia itself.
And the grounds for the suit.
It was comprehensive, really based on all the constitutional rights violations that were exposed during the exoneration process. The allegations included suppression of exculpatory evidence, the Brady stuff, outright fabrication of evidence, a reckless failure to investigate the true perpetrator, malicious prosecution, and conspiracy among the defendants to deprive Ferguson of his constitutional rights. This lawsuit went way beyond claiming simple errors. It alleged willful misconduct.
And the suit didn't just focus on the actions leading to the conviction.
No, it also detailed the continuing harm. Ferguson claimed that even after his release and exoneration, former prosecutor Kevin Crane and the former Columbia police chief Randy Boehm continued to make public statements asserting his guilt. He argued this constituted defamation and prolonged the damage to his reputation and life.
So what happened with the lawsuit? Did it go to trial?
Many of the individual defendants were eventually dismissed on various grounds, often related to immunity doctrines, but the municipalities, the county, and the city remained potentially liable. In July 2017, rather than face a full trial they seemed certain to lose, a judge approved an $11 million settlement for Ferguson.
$11 million. How was that number reached?
It seemed structured quite deliberately. Essentially $1 million for each year he had spent wrongfully incarcerated, plus an additional $1 million intended to cover his extensive legal expenses incurred fighting for his freedom.
I remember finding the city's legal reaction to that settlement really interesting. They didn't exactly admit fault, did they?
No, they were very careful. Their attorneys publicly compared the settlement to an Alford plea. Now, for listeners who might not know, an Alford plea in a criminal case allows a defendant to plead guilty while still maintaining their innocence. They do it because they acknowledge the state has enough evidence that a conviction at trial is likely.
So applying that logic to the city.
Exactly. It meant the city wasn't technically admitting liability or guilt for the police and prosecutorial misconduct. But they were acknowledging that the weight of the evidence uncovered by Kathleen Zellner was so overwhelming, those Brady violations were so clear and documented, that they would almost certainly lose badly in a full civil trial. Paying the $11 million settlement was basically the expedient way to cut their losses. But it serves really as a quiet admission of profound institutional fault.
You'd think $11 million would be the end of the financial chapter, but unbelievably, it was only the beginning of a much bigger insurance fight.
Yeah, this is where the legal and financial consequences just compound exponentially years later in 2024 and 2025. It gets complicated, but essentially the city and county were insured by Travelers Insurance. That policy was supposed to cover the municipal liability arising from this kind of police and prosecutorial misconduct.
Okay, standard practice.
Right. But in November 2024, a jury awarded Ryan Ferguson nearly $38 million in damages, not directly from the city this time, but from Travelers Insurance.
Why? Why was the insurance company paying him?
Because, according to the lawsuit and the jury's finding, Travelers Insurance had failed to pay out on a previous related wrongful conviction lawsuit settlement involving the same defendants. They essentially refused to honor their insurance obligations regarding the city and county's liability for the misconduct that led to Ferguson's wrongful conviction.
Wait, so this huge financial award wasn't just for the original wrongful conviction itself, but for the insurance company's refusal to fulfill its contractual obligation regarding that systemic failure. That seems like adding insult to injury.
Precisely. The original civil liability stemming from the misconduct was bad enough for the public coffers and reputation, but the insurer's subsequent response, trying to avoid payment, was deemed illegal and acting in bad faith, and it got worse.
Oh.
In June 2025, the presiding judge, Cole County Judge Cotton Walker, increased that jury award even further, raising the total to a monumental $43.8 million.
$3.8 million.
Yes, and the breakdown is revealing. It included $41.6 million specifically allocated for the insurer's bad faith actions, and another $2.14 million for something called vexatious refusal to pay under Missouri law.
Can you explain those terms, bad faith and vexatious refusal? They sound pretty serious.
They are. In this legal context, bad faith essentially means the jury and judge found that the insurer, Travelers, knowingly and intentionally refused to honor a clear contractual obligation to protect the municipality and, by extension, cover the damages owed to Ferguson, even though they knew or should have known the evidence of the underlying liability of the misconduct was overwhelming.
Okay, so deliberate stonewalling.
Pretty much. And vexatious refusal is a specific penalty under Missouri statute. It allows for additional punitive damages when an insurer's refusal to pay a legitimate claim is found to be without reasonable cause or excuse, basically, unreasonable and unjustified stalling. The court was effectively punishing the insurer not just for failing to pay, but for compounding the original harm, the police and prosecutorial misconduct, by dragging things out and refusing to pay the compensation justly owed to Ferguson.
That is just an astonishing final tally. It's hard to imagine a clearer financial indictment, really, of the severity and recklessness of the original misconduct that led to all this.
It absolutely solidifies the case's status and the findings of fault. Remember, the National Registry of Exonerations cites Ferguson's case as an official exoneration, not just because witnesses recanted, but because the appellate court's ruling was definitive. There was simply no evidence left that would support a conviction. This massive financial judgment in the civil realm serves as powerful confirmation that the failure wasn't just error, it was systemic, likely intentional in parts, and profoundly damaging to constitutional rights.
Amidst all these colossal legal battles and financial settlements, the personal story of Ryan Ferguson after exoneration is really one of incredible resilience and, frankly, transformation. His father's advice, given just 4 days after Ryan's arrest back in 2004, seems to have truly provided the framework for his survival.
Yeah, his father, Bill Ferguson, delivered what sounds like a brutal but necessary dose of reality. He apparently told Ryan, look, I know you're innocent, but while you're in there, I can't protect you. You have to do everything you possibly can to make yourself stronger, faster, and smarter just to survive.
That's intense advice for a 17-year-old facing prison.
Absolutely. But Ryan took that mandate incredibly seriously. He dedicated himself to rigorous physical and mental discipline throughout his time incarcerated. He actually became a certified personal trainer while in prison.
No kidding.
Yeah. And later, after release, he published a book based on his experiences and methods called Stronger, Faster, Smarter, a guide to your most powerful body. It focused on the techniques he developed to maximize physical and mental strength during that decade behind bars.
And his visibility definitely grew after he got out. He didn't just fade away.
Not at all. He used his platform almost immediately for advocacy. In 2016, he hosted an MTV series called Unlocking the Truth. It was a documentary series that investigated other potential wrongful conviction cases, trying to shed light on them.
And he was on The Amazing Race.
He was, perhaps demonstrating that sheer competitive spirit and focus he must have honed. He competed on the 33rd season of the show with his friend Dusty Harris. They actually placed third. So he really successfully transitioned from being, a victim of the system to becoming a very effective public advocate and a recognized figure.
Now, let's talk about Charles Erickson for a minute. It's such a complicated part of this story. Despite the fact that Erickson's false testimony was the very instrument that put Ferguson in prison for 10 years, Ferguson took what seems like an incredibly empathetic and forgiving stance towards him.
It really speaks volumes about Ferguson's maturity, I think, and his deep understanding of the dynamics of coercion. He seemed to recognize that Erickson himself was, in many ways, a vulnerable target for the prosecution, easily manipulated due to his state that night and his subsequent anxiety.
He actually vowed to help Erickson.
He did. Ferguson stated publicly that Erickson was used and manipulated by the authorities and, in his view, doesn't belong in prison for his role in the false confession and testimony.
Wow. What actually happened to Erickson legally after Ferguson's exoneration?
Well, Erickson had received that 25-year sentence as part of his plea deal for testifying against Ferguson. He did file appeals later, arguing his confession was coerced, but initially the courts denied them. They pointed to the fact that he had confessed to the crime, trapping him in the very plea deal that was predicated on the lie. It highlights this cruel catch-22 of coerced confessions and plea agreements. Confessing, even falsely, makes it incredibly hard to undo later.
So he was stuck.
For a while, yes. However, eventually, likely due to the high-profile exposure of the case, the clear evidence of the coercion involved in his confession, and perhaps Ferguson's own advocacy for him, Erickson was granted parole. He was released in January 2023, having served 18 years of his 25-year sentence.
So a deeply complicated narrative there, where you could argue both the wrongfully convicted man and the falsely confessing witness were victims, in different ways, of institutional pressure and misconduct.
I think that's a fair assessment.
And we absolutely must remember the original tragedy here. The victim, Kent Heitholt. Ryan Ferguson's exoneration, while crucial for justice for him, did not solve the murder. That crime officially remains unsolved.
A critical point.
And to ensure that true justice is ultimately found for Heitholt, The Ferguson family has offered a $10,000 reward for any tips that might lead investigators to the actual perpetrator or perpetrators.
That's an essential reminder. Exonerating the innocent is only half the journey toward true justice. Finding the guilty party is the other half, and that hasn't happened here yet. The case, thankfully, has been widely disseminated across major media outlets. 48 Hours, Dateline have covered it extensively.
And there was a documentary, too.
Yes, the 2015 documentary Dream Killer. It meticulously chronicled the extraordinary, decade-long fight waged by Bill Ferguson, Ryan's father, to free his son. That film provided crucial early visibility and really helped build public pressure.
And all that media attention, coupled with the specialized, tenacious defense work of Kathleen Zellner, it just highlights the vital role that external advocacy often plays in forcing accountability, doesn't it? Her determination to obtain those specific Brady materials, the hidden interview with Trump's wife, Shauna Orn's explicit non-identification of Ferguson, that was the key. That's what dismantled the systematic rot that allowed this conviction to happen and stand for so long. So, as we conclude this deep dive, the story of Ryan Ferguson really serves as an undeniable, almost textbook illustration of several critical flaws in the criminal justice system operating simultaneously, amplifying each other. We've seen the destructive intersection of, well, police pressure and profound prosecutorial misconduct. Those documented Brady violations are key, leading directly to a decade of wrongful incarceration based entirely on weak, coerced, and ultimately recanted testimony.
It really is the textbook definition of false memory syndrome, or perhaps more accurately, coerced internalized false confession, applied within a law enforcement context. Charles Erickson's genuine intoxication-induced amnesia created a vulnerability that investigators seemingly expertly leveraged, supplying the necessary details to help him construct a compelling but utterly fabricated courtroom narrative.
And if we connect this back to the broader legal landscape, those massive financial judgments culminating in that staggering $43.8 million award against the insurer for bad faith refusal to pay, they confirmed that the courts, at least civilly, found that police and prosecutors acted with, at minimum, recklessness and possibly malice in manufacturing a case based on suppressed evidence. The money attempts to compensate the individual for the immense harm done, but does it automatically address the foundational failure of integrity within the system itself?
And that raises a really important, maybe unsettling question for you, the listener, to consider. If the financial penalties for severe, documented prosecutorial misconduct can reach the tens of millions of dollars, yet the individuals directly responsible often escape criminal sanction or even professional disbarment, well, how does a society truly ensure that accountability extends beyond just financial consequences? How do we secure the ethical conduct of all actors within the justice system proactively?
That's a heavy question.
It is, because this case highlights that proving an individual's innocence, even definitively, is often merely the beginning of a much longer, far more difficult fight for true institutional change and accountability.